All right, my friends, getting a lot of questions lately about living trusts, in particular naming a living trust as a beneficiary to your 401k or IRA. Not a big fan of that, not a big fan of that at all. There's really two primary purposes for a living trust, frankly. But remember, a living trust, which is a grantor trust or a revocable trust, all right, so those three things are all synonymous. It can be revoked, changed while you're alive. It'll say right there on the front page of your living trust. This trust can be revoked by the grantor. The grantor is usually the person who funds the trust, who sets up the trust. Would be you, essentially, right? Grantor can revoke this trust at any time. At death, the grantor is dead, so the trust becomes irrevocable, as the fancy schmancy attorneys like to say. Irrevocable, can't be changed. Now, it can be changed in some regard, but you might be able to change your trustee if some guy becomes a scumbag. I've had cases that will work with people where the trustee, the only way it can be changed is by a court order or the trust firm relinquishing themselves being the trustee. And if you're a corporate trustee and you're making 2% a year on assets, and you're not doing anything, why would you do that? How that falls under fiduciary standards, I don't know. Trusts are regulated by bank law, not by the SEC. I don't know how that works. And again, as I've said many times, I am not an attorney. I do not practice law. Always seek legal counsel. Can't hurt to start that with ACTEC, A-C-T-E-C. actec.org, and click on the Find a Fellow tab, and you can find some qualified estate planning attorneys in your area. All right. Primarily what you want a living trust is your ability to manage the account from the grave. And what you're looking for is say, look, man, I got this son, he's a good boy, he's 30 years old, but he's got issues. You know, his girlfriend's nuts, or he's susceptible to illicit activity, and if I were to die and he were to inherit $1 million, they'll probably kill him. So the way to do that is to set up a living trust as beneficiary. You're naming it's called a successor trustee to manage the trust, so that way little Johnny cannot get it all in one fell swoop and shoot it up his nose or shoot up his arm or sniff it up his nose and kill himself. That's one of the benefits of a living trust. Probably the second most benefit of that is that way you can keep him from himself. The drawback, of course, is what if you forget about that living trust? 15 years go by and you still have the same situation. Now little Johnny's a freaking, he's gone through he's just a holy roller. He's kicking butt, taking names, and now he's still set up that way. And now he can't have access to it because you forgot to change your trust. You forgot to change the documentation. So you're protecting him from himself, but he no longer needs that protection. That's the drawback about a living trust, so that things do change. All right. So living trust, you protect your assets, your kids from assets and hurting themselves. Think about it this way. A living trust can be set up to keep creditors and predators, in-laws and outlaws at bay. I've always liked that saying. Heard that about 20 years ago and always kind of stuck with me. Creditors, predators, in-laws and outlaws. So living trust can make sure that little Johnny doesn't get the money and give it to predators, drug dealers, doesn't get the money and squander it by the bank saying, oh, you got this money, Johnny, give it to us. No. And remember, the IRA, a beneficiary IRA, is absolutely subject to creditors, just FYI. But it's a retirement account, Josh. Yeah. Non-spouse beneficiary, Supreme Court ruled in 2014, unanimously now. Sotomayor to Clarence Thomas, everybody in between, that beneficiary IRAs are subject to lawsuit for the creditor. They're not exempt from creditor protection. A lot of people don't know that, and they should. So just because you have an inherited IRA does not mean you have exclusion from creditors coming after you. All right. So little Johnny, we don't want him to shoot up his veins or sniff it up his nose. So that's where you want a living trust as your beneficiary. I hear all the time living trust can keep you from probate. Well, yeah, but probate's not that hard, man. Now, if you got assets in multiple jurisdictions, sure. You got, Tucson, Arizona, Rocky Mountains, Colorado, wherever that is, Seattle, Washington, and Gulf Shores, Alabama. Yeah, living trust would make sense there, because if your son, who's your executor, or your daughter, who's the executrix, lives in Boston, do you really want them flying to 4 different jurisdictions to probate those real estate holdings? No. So a living trust, you put it in there because essentially you're pretty much doing the probate before you die anyway by moving those assets into your living trust, so that way when you die, your kids don't have to do that. That makes sense. How many of us have that? Not many. All right, on top of that, probate is not hard at all to avoid when it comes to bank accounts and investment accounts. An investment account is a TOD, man, transfer on death. You got a joint account with your wife at Schwab. You say, when I die, it's joint tenants with rights of survivorship. It goes to Charlotte. When she dies, it goes to me as individual owner. But we want to make sure when we die, when the survivor dies, it goes to the kids 25% across the board. You have a TOD. It's just literally a piece of paper you attach to your account. It says Charles Schwab, joint tenants with rights of survivorship. Josh Scanlon and Charlotte Scanlon, owner. Transfer on death arrangement, 25% to each of these 4 children. At death, that does not go to probate. Done and done. Easy as pie. Bank accounts, the same thing, except it's a POD, a payable on death. It's easy. It's just a 1-page document. Click, click, done. I'm sure some would require notary. A lot don't. When I was at USAA, we didn't. I don't know what's going on now, but just keep that in mind. So a TOD, a POD, beneficiary designations on all your assets, IRAs, life insurance, annuities, TOD and POD on your non-IRA 401k assets, and all that stuff is bypassing probate anyway. Going to probate to transfer the title of your home to your heirs, if you only got one house in freaking Georgia, Alpharetta, for instance, look, 7,700 people die every day in the U.S. 7,700 every day. Probate in of itself is not the worst thing to ever happen, for heaven's sake. There are some benefits of probate, by the way, which I won't get into here, but the issue is you go down to the freaking county courthouse. My dad died. His will says he's leaving his house to me. Here's a death certificate. Here's a will. The judge on the probate court says, yep, granted, click, click, done. There's a little bit more to it than that. There's a little bit of fees in that and all that, but it's not that big of a deal. People act like probate's the worst thing that ever happened. The reason probate can be so problematic is because you don't have your estate planning up. You forgot to change title when your wife died, and you still have her as beneficiary of your life insurance. It's still joint tenants of rights of survivorship, or it's still a deed. Both your names are on the deed. And you've long since been divorced. There's so many different things. Your first wife is still beneficiary on an IRA that you had from 1978. All that stuff is a pain. But guess what? Just keep your estate planning, your account titling up to date, and you're fine. It's just not that big of a deal. But Josh, probate is a public. Probate is a public proving of the will, so everyone can get to know your business. That's true. Living trust is not. TOD, POD, beneficiary designations are private as well. No one knows who's going to get your money if your account titling is correct. Now, if you got a bunch of guns, you got a bunch of baseball cards, you got a bunch of knickknacks, and all that needs to be probated, theoretically, that would be subject to people could find out what's going on there for sure. You got your house, people could find out what's going on there, but believe it or not, they can find out that now anyway. All you got to do is look at the titling of your house. You can go to any county courthouse GIS system. It was a geographic information system, GIS, and you could look up plots, you can look up mortgages for anybody. You can look up ownership. All that stuff is publicly available. So probate's private, probate's public, well, everything's public. Living trust are private. Okay, well, that's You can even see who the living trust owns. You can see a living trust. You can see if it's a grantor trust, revocable. You can see all that stuff. That's what I tell people all the time. In this day and age, my friends, there ain't nothing private. Just keep that in mind. Everything's known. So, look, finally, the Secure Act got rid of the stretch IRA rules. A lot of people have living trust as a beneficiary to take advantage of the stretch IRA rules, so to make sure that someone didn't squander the opportunity to pull money over their life expectancy as opposed to within a 5-year distribution lump sum. Or right out the gate. Lots of children notorious for receiving after 25 years old granddad's $100,000 IRA. And instead of stretching that over their life expectancy and only taking the RMDs, they take a $100,000 lump sum distribution, and now they're paying 25% of taxes. That's one of the things that the trust could do to keep you from doing that. Essentially say, we're going to make sure you follow the stretch IRA rules and not pay one lump sum and pay this huge tax hit. Problem with that is Secure Act got rid of all that anyway. 10-year distribution scheme now for inherited IRAs, non-spouse beneficiaries. So that's gone. Never mind a living trust. I mean, literally, you can't put an IRA in a living trust. You can only name a beneficiary designation as your living trust. So now your living trust inherits the IRA. They still got to send those RMDs out to the children. A living trust can't retain those assets. I mean, if it does, they're going to get taxed through the Wahoo or Wazoo, whatever it is. So it's just a pain in the butt, man. And there's really no huge benefits because of 10 years, that you have to have the thing exhausted within 10 years now anyway. So I mean, look, man, I'm sure there's a reason more that I'm missing here, but the reasons are fewer and fewer now. The big thing for me is make sure that your kids don't squander that by shooting up their veins. That's the big one right there. Or they have special needs. Special need kids, of course. We got to make sure they're protected by not inheriting those assets at one time where they could sacrifice government benefits or they get hammered tax-wise. So that would be another thing too, special needs. But basically special needs to take care of your children, or just make sure your kids don't hurt themselves. I hope this helps. Love to hear your comments. We'll see ya.